So I've had some recent questions from some clients, and so I've invited Sam Bergerman to come in and help explain a little bit about what happens when an estate is being probated and settled. And my first question to Sam is just really what's happening and what does it mean to probate a will?
Well, when we're talking about probating a will, really what we're talking about is applying to the court for what's called letters probate. Essentially what letters probate is the courts granting the authority to the executor of the will to deal with the estate assets, all the property owned by the deceased.
Okay, so how long is that process typically? Is that something that happens instantly or?
Certainly not instantly. There's a lot that goes into finalizing an estate. I mean, if you think of all your assets and you think of what you'd need to do to sell them and dispose of them all, I mean, I think of myself trying to sell a phone on Kijiji and how long that takes.
Yeah, good example.
In any event, so there are a number of steps. And the first step is getting to that point where you can apply for letters probate. And I should back up a step. The first step is making sure we've got a valid will and making sure we know who the executor is. Assuming, and in most instances, you do know who that executor is, there's somebody close to the deceased. Assuming there's no issues with the validity of the will, you know, there aren't two wills out there or something like that. The first step then for that executor is, number one, you want to inform the beneficiaries that they have an interest in the estate. Oftentimes you'll want to do a will reading, particularly where there's lots of beneficiaries. And that will reading will serve two purposes. One is to let them know what the will says and what they might expect from the estate. And number two is to give them a sense of the process. Let them know how long this can and will take. Once you've done that, as the executor, you are first and foremost figuring out what are the estate assets. So
do you find when this term settling the estate takes a little bit longer, is it because of the executor or I guess the complications of the situation? But you know, when it seems to go into a black hole and nothing's moving along, what are some of the reasons why that might happen?
Well, so I'll just sort of go through the steps of what you need to do.
Okay.
Number one, you're preparing an inventory which will be necessary for that application to the court.
Okay.
That inventory is going to outline all of the assets of the estate and the values of those assets. Figuring out those values, that takes time.
Okay.
Figuring out what all those assets are, that takes time. Okay. For example, I know the deceased has accounts at RBC and this credit union. I have to send a letter to the credit union and RBC, provide them a copy of the will perhaps, and do whatever they need me to do for them to provide me details of the account.
Okay. So just on that topic then, it would be the lawyer that gets involved in doing this, or the executor is actually contacting the institutions? Or I guess it could be either.
It could be either.
Okay.
Generally speaking, I would do that as part of my services to the client.
Okay.
So as you're preparing this inventory, there's a number of other things to consider. Number one, if you're looking at, if you've got a house, for example, you need to contact the insurer. Is there anybody still living in the house? If not, make sure the insurer knows that there's no one living and make the arrangements to ensure that insurance will remain in place. Yeah. Where you've got vehicles, to maintain the insurance on those vehicles, you have 60 days from the date of death in which to transfer that insurance. And usually you would transfer to the beneficiary. In some instances, you're transferring it to the executor as administrator of the estate. Applying for a CPP death benefit, which helps defray sort of costs of the funeral. Preparing and dealing with the funeral often falls to the executor. You know, There's also other properties such as life insurance, contacting insurers, figuring out what they need, filling in the applications to apply for that insurance, where there's a spouse and CPP applying for spousal benefits, those sorts of things. So you're going through that entire process, not to mention securing assets, making sure that everything is safe and nothing's going to get stolen, if those sorts of things.
So what about with the tax year? Can you actually settle on a estate before, like you wouldn't be able to settle and disperse assets before the final tax returns have been processed, correct?
So
does that delay it any?
Absolutely. So once you've made this application and obtained letters probate, and now the executor has the authority to deal with all the assets, you can, as the executor, collect all the assets, apply to have bank accounts transferred into the estate account, apply to have get that life insurance into the estate account. Basically transmit land, so the land titles registry will not allow any transfer of land without the authority of letters probate, or letters of administration in a situation where there wasn't a will. So once you've got all that taken care of, you've got all the valuation done, you usually have the accountant preparing the final return. They're going to be likely submitting the inventory, and CRA will review that. That process in obtaining that final tax clearance certificate is often 6 months plus, particularly if there's any issues. So
if someone passed away, say in May of the calendar year, and you weren't able to produce all of the required slips for that person, would you file 2 returns, one for that current year and then the following tax year, or how does that?
There are often times where you will file an estate return, and so that may take, and I think you can do that up to 2 years following the death.
Right.
But that's more of a question for the accountant than me.
Right. So then what about, obviously the executor needs to not disperse all the assets in the event of when the tax filing is done, there's estate tax due. So it seems to me that would stall things a little bit on dispersing all the assets.
Yeah, so the things that the executor has to make sure is that all debts are paid and that the taxes are paid. Because you don't want to get into a situation as an executor where you've distributed all the assets and all of a sudden there's a big tax bill which falls to you if you can't.
That's right. Oh, it would, yeah.
Right? Yeah. So from that perspective, a lot of it is making sure that that everything's paid so that once you disperse, you're not going to be in trouble as the executor. I mean, it's a big job. You're taking on a lot of work, and oftentimes the people who you're working for, essentially the beneficiaries, are impatient, and and understandably so. I mean, that's just human nature. At the end of the day, when you're settling the estate, oftentimes once you've gotten to that point where the accountant is ready to file that final tax return, you have a sense of how much tax you're going to have to pay.
Right.
And what you would do in that situation is hold back a certain amount of the estate, and then do an interim distribution.
Right. And beneficiaries should be entitled to updates and some information on what's happening along the way.
Generally you'll want to provide that as an executor. And at the end of the day, you're going to have to provide a final accounting. And that accounting will talk about all the liabilities, all the assets, the asset values, what they were sold for, and any expenses incurred in administering the estate.
Right,
you can't expect the executor to pay out of their own pocket in order to help them do the work to deal with the estate.
Well, I definitely think you cleared it up. I know for me, just by segmenting it, you've almost simplified this complicated process, but also shows why it takes so long, and I think why it can go into a black hole sometimes. And
absolutely.
Because beneficiaries do get impatient, and they wonder, like, what's going on, and why can't I get my money, and what's happening, and there doesn't seem to be a lot of feedback from, where it's at. so
Yeah.
that makes a little bit more sense.
And I think for most executors, it helps to, that initial meeting with the beneficiaries, telling them about all of these things, letting them know how long
Right,
things can
yeah.
take, and why you have to
Yeah.
wait for these things.
Yeah. And I'm sure it's coming from the advice as the accountant and the lawyers to say, like, slow down, don't disperse the assets because of the
Right.
unknowns and uncertainties.
Well, if you disperse everything and all the beneficiaries
Yeah.
spend it, and then all of a sudden there are debts and liabilities
Yeah.
that you have no way to pay for.
Right, yeah, falls on the executor.
Yeah.
Perfect. Well, it's very helpful. I really appreciate you coming in and
No problem.
clearing that up. And yeah, thank you.
Excellent.
Kate, can I ask you another question?
Absolutely.
So I'm just going to ask you.
Yeah.
I don't know if I should intro it, but so how often and what really happens if a person has two wills? Or how do you ensure when you have a will that it's the final and last will that a person has?
Well, generally speaking, almost every will you will start with a clause that says, I revoke any former
Right.
or prior wills, and based on the date of the last one, that's the one that will take precedence. Now, where there is a situation where it's not clear, that's a matter for the court
Okay.
to determine.
Okay.
And because in that situation, oftentimes you may have two different executors, one named in this will, one named in that will, and
Yeah.
one of them has to make the application, and then the other would have the ability to put forward
Right.
the information they
So
have.
obviously dispose of all prior wills if you have access to them.
Generally speaking, you
Yeah.
wouldn't want. I mean, if you've made a decision to change what's in your will and you've got an updated will, disposing of prior wills is a good practice.
Yeah, perfect. That's great.
Yeah,
Thank you.
no problem.